Well, I think what Daniel said was short, but I'm not quite sure I think it was sweet. Let me see if I can try to give an alternative account as to why it is. I think the question is a good deal more complicated than that. And what I want to do, in effect, given what he has said, is to start with his first proposition, which says, do you think there's a risk that property rights could be made too strong with respect to the system in question, to which he basically gave you the extreme case, and only one person in the room was foolish enough to raise his hand, simply to stress the fact that he was 100% correct. But when you're creating an independent property system, that's the wrong question to ask. The right question to ask is, how do you balance the areas of over and under enforcement, over and under creation of property rights, so that you could do exactly the same thing if you wanted to march the argument off in the opposite direction and say, do you all believe in a property rights system in which you have 1 hour worth of protection and 1 cent maximum damages? And everyone would say that there's something deeply wrong with that. So the question you then have to do is to figure out where in this particular system you want to make the intermediate solution, and have to decide on what particular dimensions you wish to do so. The basic thesis that I would want to defend is that the key feature with respect to intellectual property that marks its differentiation from other forms of property is, for the most part, the question of the duration of the interest. And it depends on what industry you're talking about. For certain patents, like software patents, 20 years protection is essentially an irrelevant issue because economic obsolescence simply shortens things. But if you're taking something like Lipitor or a drug, every additional year really matters, because one of the things that we find out about pharmaceuticals is that their value does not necessarily depreciate over time. If it's shown by adequate clinical trials and subsequent usages to be a very safe and effective drug, it will increase over time so that those additional years will not be subject to the same kind of obsolescence. And so when you have the corrections that were made in the 1984 universe under Hatch-Waxman, those turn out to be insufficient today, and clearly you want to rejigger the clock so that the effective period of marketability exclusivity is going to be more than the 9 to 11 years it turns out to be. The question then is, how do we start to deal with this? And what I want to do is to take a leaf, probably the only sensible sentence stated, or one of the few, in the argument that happened the other day in the Bielski case, which I thought, from the point of view of the justices, they did not give this problem anything like the respect that it deserved. And I'm quite willing to say in public, if intellectual property is going to be put into the hands of a bunch of stand-up comics, I think we're really in very, very bad shape. And that's exactly the way they performed on the day. I hope this is on tape. But Justice Breyer did ask the following question, to which he gave a skeptical answer. He says, as far as he can see, there are 4 variables. He's wrong about that, but let's just assume the 4 variables you talk about with intellectual property, 2 of which are pro and 2 of which are con. And he said the pro variables we have is that when you create an exclusive right to something, what you do is you increase the willingness to invent, assuming it's protected by an adequate set of remedies. And then in addition to that, he thought there was another benefit in the fact that in order to get a patent, you have to make disclosures of best modes and similar kinds of issues so that the public benefits from the generation of information that would not otherwise be acquired. Then on the negative side, he's quite right to say, if you look at it, when you create a patent, to some extent you're going to have monopoly deadweight losses because marginal prices that you're going to charge are going to have to be sufficient to cover the cost of creation, which means that you're not going to be able to get things down where every person who wants to use the system can use it. And that's a downside. And he also said that if you're going to run this system and not keep things in the public domain, what you have to do is you're going to have to create a licensing system which is more costly than the free, simple use and acquisition. Those were the 4 issues that he talked about. And then he said, I don't have a clue as to how these things start to come out. There is a 5th argument that is commonly made, which is the so-called Pack and Thicket argument, which says that as you add additional patents, you create more and more obstacles to effective technological deployment, which means that the excessive fragmentation of rights is also a problem. So the monopolies are few and strong, which is bad, or the monopolies are many and diffuse, which is also bad. So the system, in fact, is under disrepair. Now, what I think you want to do with respect to this argument is to not simply say we don't know, but to try to figure out what we do know and then see how it is what we know actually tells us something about the operation of the system. So let's begin with the first of these points about the nature of the monopoly game. And here, what one has to do is to say, yes, there is going to be an exclusion, but you have to ask the question of how much that exclusion is going to be. And I think if you take the simplest models, the most that you could come up with as a cost of exclusion would be 25% roughly, if the system, assuming that the same technology gets online with the patent at the same time that it gets online without the patent. That is, when we start dealing with patents, we know that there is going to be a monopoly price. There will still be some substantial amount of consumer surplus, and there'll be a transfer from the competitor to the, or the buyer to the seller in the form of the monopoly rectangle, and there'll be a deadweight loss. And this is clearly a source of wealth destruction. On the other hand, it is a mistake when you're thinking about patents to think about the situation as if this is an economic monopoly simply because it turns out to be a legal monopoly. That is, when you have an exclusive right to deal, the patent system has to define very carefully what the appropriate scope of a patent is going to be. And generally, you cannot patent a technology, the use of the spectrum and so forth. What you can do is to patent a device or a machine or a technique that exploits it, which means, in effect, that other competitors can come in. So if you're trying to figure out what the effective losses associated with monopolies are going to be, you have to ask yourself about the likely time that the second patent is going to come in. And if the rights are well defined and secure, what we've discovered over time is that the generations between innovations get smaller and smaller, which means that the dissipation of the monopoly rent takes place at a more rapid rate, which means, in effect, that patents essentially create competitive markets rather than creating monopolistic markets, and that the information that's supplied, in fact, is going to be very useful. So at this point, when you look at the two negatives, the one on the deadweight loss and the cost of licensing, this is the reaction I think you ought to have. If we could control the deadweight loss by simply moving the thing forward a little bit, we would much rather have a deadweight loss from monopoly than no gain and no loss from having no innovations at all. And so I don't think that there's any serious question that patent innovations can have strong positives. The question is how it works across fields. And in areas like pharmaceutical, I think it's the one area where it's unambiguously a gain. And when you start looking at the change in levels of investment after the adoption of the Hatch-Waxman Act, or if you look at other technologies in biotech after the expansion of patent eligibility and so forth in the early 1980s, the gains that you see from innovation are simply enormous. And then there's the question about licensing, and I think the right answer to that to say is licensing is a cost, but we're really not quite sure how much of a cost it turns out to be. One of the things that we know is that the Bayh-Dole Act basically said when you put things into the public domain, they seem to languish. So there was a real effort on the part of Congress to actually create property rights for commercialization. And as far as I can tell, that seems to actually have some sort of a positive benefits. So that last particular cost of transacting seems to be dubious. And if you want to find out why the transacting is inefficient, you have to look no further than the same August 9, because when they wrote the Quanta case, they so bollocksed up the way in which you start to think about licensing that the net effect of this situation was to make the patent transfers much less efficient and much less certain than they were, so that if you are serious about this issue, what you want to do is to not only have clear rules with respect to formation, but in addition to that, what you also have to do is to have effective rules with respect to license transfer. And every decision that they make which impedes the transferability of these things turns out to increase the social worth or the cost of the patent system. Now, the last point that one wants to make is the one about the patent thicket, which they did not address. But again, it seems to me in many cases to rest upon a very serious kind of misconception about how the world actually works. The common model of the patent thicket is any time you add another patent, there's another hurdle that you have to negotiate. So you think of somebody trying to do the 110 high hurdles, and you originally start with, say, 13 hurdles, and by the time you're done, you got to go over 25 of them, and everybody trips at the 6th. I don't think that's the way it works. What you have to understand is that the introduction of new patents in many cases renders unimportant and obsolete many of the other patents that are still on the books. You could always use the old technologies. Now they're giving you a new pathway. So instead of treating these things as blockade or toll booths along the river. It's in the opposite direction. You're trying to cross the river, and the new patent may give you a second way to cross the river as opposed to the first way to cross the river, so that you can draw absolutely no inference whatsoever from the increase in the number of patents to the question of whether or not there's improper congestion or over-improvement. And this inability to see that patents are in competition with one another and to imagine that they only operate in series, one after the other, is, I think, a source of a major intellectual defect.